Do you plan to start employing new workers, or do you already employ individuals and would like to get more information about what you as an employer should do to protect your business to make sure that you operate in compliance with the local laws and regulations in Canada? Welcome to Business in Canada Do It Right, and me, Eugene Jakubov. This is the topic of today's presentation. So before we start talking about what you should do as an employer, I think that the first step is for us to understand as employers what is the extent of our liabilities, what are the sources, directions of liabilities, in order to then approach the mitigation through the proper documentation and other steps that I'll talk about them today. So first, we of course are responsible for multiple monetary payments to our employees. I call it wages plus, but essentially it's everything that we must pay to our employees during the employment, such as wages, overtime, vacation, statutory holiday, and the termination of the employment, such as termination notice and severance pay. We also are responsible to provide to our employees proper and safe, healthy workplace and work environment, both from the health and safety perspective, but also from the perspective of prevention of violence and harassment inside the workplace and outside, meaning from third parties such as clients, visitors, etc. We have multiple responsibilities towards multiple government organizations such as CRA, Canada Revenue Agency, WSIB, and some other organizations. WSIB could be called differently in other provinces. It stands for Worker Safety Insurance Board in Ontario. These require us to keep certain records, pay certain contributions and premiums, and also report in the case of some unforeseen circumstances. I'll talk about it in a moment. The third parties, we're responsible as employers for everything that our workers do. In the legal language, it is called vicarious liability. Essentially, it means we will be liable for almost everything what will happen during the performance of their duties by our employees. And that brings me to the point that the bigger our workforce, the more employees we have, the less control we have over what they do. We will need to undertake certain steps to protect our business. We, of course, bear reporting responsibilities toward different government agencies, employees, and more. We have to understand what are those reporting responsibilities and how to approach it at certain time when the time comes. Second major point of concern for us as employers is the understanding of how the Employment Standards Act works in Ontario, but in any other province as well. And essentially, its presumption is that this Employment Standards Act is mainly protects the interests of our employees, not us as the employers. Employment Standards Act sets the minimum, so we cannot offer anything which is below the standard provided by the Employment Standards Act. We can offer only more, but we also would want to define what is more that we offer to employees in order not to open the opening for them to prove later on that they were entitled for more than what we were paying to the employees. It is very important to understand that the Employment Standards Act does not provide protection to many of our very important interests, such as non-solicitation, non-disclosure, non-use of proprietary information, and more. I'll talk about it in a second. And to add to that, we have to understand that the courts are mostly work from the perspective of protecting employees. They will be pro-employees. Most of our legal battles, I hope we never get there, but if we do, we will be fighting uphill battles where the system, the Employment Standards Act, and the courts are essentially working in the favor of the employees, and we will have to prove what we would consider as the right or reasonable in the circumstances of the legal claim. So when we understand this, you will understand my first point is that incorporate. Make sure that as soon as you, or before you start employing individuals, you incorporate it, you've created a separate legal entity. So if anything happens, your company is being sued, not you personally, you protect your personal assets. Doesn't mean that you shouldn't get an insurance, but this, in addition to insurance, will protect you personally from unnecessary liabilities and claims. Understand the vicarious liability. Again, anything that happens during the performance of their duties by employees, we will be responsible and liable. Another reason to protect us personally from those operations through the corporation. But don't forget that as a director in that corporation, we still will be liable for multiple administrative responsibilities, reporting, payment of taxes, payment of sales tax, payment of wages to a certain extent. There are multiple protections that the laws provide and impose on us as directors. So incorporating is not a bulletproof protection from anything and everything, but you have to understand the system. Second is have a proper employment agreement in place. Employment agreement provides those additional protections that are not included in the Employment Standards Act, and make sure that you think about your interests, that you consider them, and then include them all in the employment agreement, both for the duration of the employment, but also at the termination of the employment, and I'll talk about it in a moment. Define what is important for your business, but keep in mind that in Ontario, as of 2022, the inclusion of non-compete after the employment was considered is illegal, and there are certain exceptions for executives and during the employment. My personal approach is do not include non-compete in your employment agreements. Protect your other interests that will mostly cover non-compete, such as non-solicitation, so essentially preventing your workers from soliciting your clients or your suppliers to stop working with you and move to work with them. Confidential information, proprietary information, training. If you provide training to employees, make sure that you define the training materials as confidential, so this way you can prevent employees from using this in the future. Define the terms of separation. And the terms of separation will include the termination, the length of termination notice. Remember, you cannot define less than what the Employment Standards Act provides, but I usually suggest my clients provide more. Define additional payment as a severance pay. So in the future, you will be more protected if the employee wants to sue you for higher severance pay. If you provided nothing, is essentially opening the doors for the court to add whatever the court thinks is reasonable. But if you provided something, you can say that that was the reasonable determination of the severance pay, and essentially it will be higher to impose on you additional liabilities for the severance pay. Define additional rules. First of all, change of employment terms. Now, by the Employment Standards Act, you can't really do that. So make sure that you can adjust the terms of employment, the duties of an employee as the time progresses. Make sure that you include the reference to your book of policies and procedures through which you will be able to regulate how the work is performed, the health and safety, and multiple other issues at the workplace. Also define the layoff right of you as an employer. There were multiple employers that paid a very dire price during the COVID market lockdowns when they were forced to lay off the employees, but the employees sued them, saying that because the employment agreement did not include the right to lay off and the Employment Standards Act does not provide this right to employers, those employers ended up paying very heavy severance pay and additional compensation to employees because the courts found them having no authority to lay off employees if that is not included in the Employment Standards Act, in the employment agreement, sorry. Understand your payroll accounting. Understand how the system works. First of all, as the employer, you will need to deduct certain deductions from the employees' salaries. Of course, income tax, pension plan, employment insurance. You also will need to add additional contributions as the employer. In addition to that, you are obligated to pay WSIB premiums if you fall under the coverage. Learn the system, go to WSIB website, check that your business operations are mandatory covered or not. If your business grows bigger and you reach certain annual volume of salaries, you also will be subject to the employer's health tax, which is an additional payment to the government that you will have to pay. Also understand when to pay. So for example, your deductions and contributions, together called remittances, must be done by 15th of the next month for the previous months. So let's say if you paid salary, made deductions for the December, you will need to pay the remittances to the CRA by 15th of January, and so on and so forth. Use the Ministry of Labor Employment Standards Act guide. It is extremely useful database and source of information. Here's the link. I also will include it in the description section below. In my opinion, it provides answers to many general questions. It also will explain to a certain extent non-standard situations, at least will give you basic understanding of what is required from you. And then if you still have questions, you can contact us. We will definitely help you to get better and further understanding of what is required in those particular situations. Understand the responsibilities of the posters. So the ESA will explain it, the guide, but also essentially as the employer, first of all, you need to provide employment standards poster to each employee that you hire. Then depending on the type of your operations, if you're staffing or if you're some other business operations, you will need to provide additional posters to your employees. Finally, there are multiple posting requirements to you as an employer. I'll touch base that point in a second. So then understand that as an employer, you also are subject to certain rules of compliance. Many of them are mandatory. So first of all, of course, health and safety. Health and safety is mandatory from the very first employee, but you're required to have a written policy as soon as you reach 5 employees. In my opinion, don't wait. Prepare written health and safety policy as soon as you start employing, so you control how the work is performed, you regulate certain health and safety standards, but you also later on can prove that your workplace was compliant and operated in compliance with the regulations of the workplace health and safety. Accessibility for Ontarians with Disabilities Act. It is a very important act which is mandatory to every single workplace, whether you employ people or not, because the AODA applies both to your employees. So you have to provide accommodation to employees with disability, but also to your clients. And so the act applies as soon as you start operating. Make sure that you understand the act or talk to us. We'll help you with the policy. Human rights essentially is the prevention of discrimination, whether at the hiring, employment, or working with the clients. So your employees cannot discriminate. They cannot be discriminated, and you are, as an employer, responsible for the protection of every side involved. Make sure that you have proper human rights policy that defines what discrimination is, the complaint procedures, investigation procedures, and much more. Let us know if you need help. Prevention of workplace violence and harassment. It is very much attached and connected to the health and safety environment, but requires separate policy. And privacy. So today, most of the businesses collect multiple information from its employees, from its clients. Make sure that you have proper privacy policy that defines what you collect, why you collect, how you collect, protection to that information, how you can use that information. As you know, multiple laws regulate these provisions, and make sure that you're in compliance with regards to the protection of privacy of every party involved, but in particular your employees for the today's presentation. So here's a short hiring checklist. Of course, it's not a all-inclusive, and it will change depending on what you plan to do, but it will give you the basic understanding of what is required. So first of all, prepare proper intake form, get proper information, scope of information from your employees. Many of these documents you can find at our new project, businessdocs.ca. I'll put the link in the description below. Get the information about banking, how to pay the salaries, next of kin if something happens. Employment agreement, prepare employment agreement. I already spoke about it. I think it is hard to overestimate the importance of this document. Make sure that you have a proper health and safety training for your employees. Basic training is provided for free by the Ministry of Labor. Don't buy it. Go to the Ministry of Labor website. I'll put a link again in the description below. And every employee that you hire must either possess the certificate that the employee passed previously this training, or you must ensure that the employee passes. In any case, make sure that you have the certificate in the employee's file. Build a proper book of policies and procedures. Make sure that the employee receives it in advance or as soon as they start working, and sign it after they had an opportunity to review. Do not force employees to sign anything on the spot, because that could be used against you in the future. Give an employee proper opportunity to learn the documents, the policies, the procedures, the employment agreement, and sign later. Make sure that the proper employee training is provided at the workplace. So you as employer are responsible to ensure that the employee knows how to perform their duties, knows what are the health and safety regulations at the workplace already, and you're not allowed to provide employees access to the workplace without ensuring that they know what they do. Keep the records of every step that you do. Understand how the WCB applies to your workplace. Some types of businesses are exempt from WCB application, and if it's exempt, then think if you need it, talk to us. I can guide you into the right direction. If you're mandatorily covered, there's no choice. You have to apply for WCB registration as soon as you hire your first employee, and you will need to pay the WCB contributions or premiums based on the percentage assigned by the WCB organization to your particular type of business operations. Here's the checklist for the posters that you as an employer must provide to employees. So first of all, Employment Standards Act, know your rights. You have to provide this poster to each employee as soon as you hire them. Also make sure that you post it at the conspicuous place, usually kitchen where every employee comes, or a dressing room, or whatever the place that you can know that every employee will see the poster there. Health and safety at the workplace poster. The Occupational Health and Safety Act, a copy of the actual act should be posted at the workplace. I also suggest send it by email to all of your employees to make sure that they have it and you have the proof that you did it. In case of injury, this is a poster that is usually offered by the WCB for free. Don't pay money for any of these posters. Everything could be done for free. It is 1, 2, 3, 4 poster, usually known as, and it explains to employees what to do in the case of injury and to you as well as an employer. As soon as you reach 5 employees, you must have written health and safety policy. In my opinion, have it as soon as you hire your first employee, so everything is properly determined in the document and you have proper record that your workplace is compliant with the health and safety requirements. So this is more or less the scope of what I think that you as an employer must prepare to ensure that your workplace is protected, compliant, and operates in compliance with the laws and regulations, but also make sure that your employees understand what is expected from them and define proper protections to your workplace. So thank you for being with me today, Eugene from CBS, Canadian Business and Enterprise Services. If you need more information, contact me. The contact information is on the screen. If you would like to download the documents, visit our businessdocs.ca. The project offers certain documents for free, others for pay, but at a fraction of the legal documents. The documents are very thorough and detailed and will help you to build your workplace compliance, but also protection in the case of the employment. And that is it for today. Thank you for being with me and good luck with your business. Bye-bye.